So while we're setting up, I'll just repeat the disclaimer. These are still my personal views and not the views of the institution, although this is probably less relevant here because the text has already been adopted and published. I will not talk much about the background because it was already presented by Agatha. I will just mention that the regulation was published in the official journal on the 30th of June. However, keep in mind that a corrigendum was published on the 28th of July, which only changes a bit the date of application, corrects when the date of application is, that it is actually the 1st of April 2018, and then corrects the dates that follow from that date. So without further ado, I will just go into the content. Article 1, subject matter and scope. The regulation introduces a common approach in the Union to the cross-border portability of online content services, and it does not apply to the field of taxation. So why? Why did we need this regulation? As usual, the answer is to be found in the recitals. They explain what were the needs, what were the possible solutions, and why this was chosen. The problem that was identified was that with the, again, development of digital technologies, you have much more possibilities now to access content wherever you are. You have tablets, you have smartphones, you have laptops. So, for example, when I traveled to Germany, I took my iPad and I could use it to watch Netflix if I wish to, because I have a Netflix account. However, what was established is that often consumers who have lawfully access to content in their member state of residence cannot access this content when they are temporarily present in a different member state. And in the same time, because of the increase of the use of portable devices, there was an increased demand on the side of consumers to access the content that they have lawfully acquired and often paid for in their member state of residence, also when they're temporarily present in a different member state. The reasons why often they couldn't do it are many. You could have issues with copyright on union level. When it comes to sport events, this could be copyright at national level or a different type of protection. You can have issues that the rights for transmission of the content for the member state of temporary presence are not there, or that the provider does not serve that particular market. Whatever the reasons, the Commission felt, and the co-legislators agreed, that in a smoothly functioning internal market with freedom of service, freedom of movement of persons and services, this should not be the situation. And that is why they introduced this regulation, which only covers the cross-border portability. However, this is important to note, and it is specifically mentioned in Recital 12, the regulation does not cover cross-border access to online service content provided in a member state other than the member state of residence. So, for example, my member state of residence is Belgium. What is covered is that when I'm in Germany, because I have a Belgian Netflix account, I can access the Belgian content of the Belgian Netflix account. What is not covered is that I am in Belgium, I want to access the UK Netflix content. This is not covered by the regulation. This is cross-border access, and this is a different issue. What is covered is cross-border portability. My right to access the Belgian content is portable. It follows me when I move around the Union. As far as taxation is concerned, that was an insistence of the Council that we include this, and there is also Recital 13, which also says that the regulation does not apply to the field of taxation. Definitions. There are a number of definitions provided in Article 2. These are definitions that are for the purposes of the regulation, so they are not definitions that apply outside of that particular act. First, we have the definition of a subscriber. A subscriber is a consumer, which is also later defined, who is entitled to access and use a service in a member state of residence on the basis of a contract. This is also defined, but in a recital, with or without payment of money. Consumer is a natural person, so only natural persons are covered, who have a contract. This will be, I will talk about it in a second. And this contract, they're accessing these services for purposes outside trade, business, craft, or profession of that person, so it's basically for personal use. So contract is not defined in Article 2, but it is in a way defined in Recital 15. For the purposes of the regulation, a contract is an agreement, any agreement between a provider or a subscriber, including accepting the terms and conditions of the provider's website for the provision of the service. Member state of residence and temporarily present in a member state. These two definitions were very controversial to the very end. How do we define the member state of residence and how do we define temporarily present? Finally, the compromise found was that a member state of residence will be defined as the member state as determined through the verification means set out by this regulation, where the subscriber has his or her actual and stable residence. This last addition was very controversial. The Parliament felt that if you add this last bit, you might force the providers to, on top of verifying the member state of residence, to verify that this is exactly where the subscriber has an actual and stable residence. So an additional element of proof will need to be added that this is where the subscriber has the actual and stable residence. So in order to deal with this concern of the Parliament, we have Recital 14, which says that a provider of an online content service who has verified the member state of residence according to Article 5 can assume that this is it, this is the member state of residence, and that provider does not have to check whether the subscriber has a contract with a different provider with a different member state of residence cited in that contract. And then temporarily present in a member state was defined as being present in a member state other than the member state of residence for a limited period of time. Again, the last bit was extremely controversial. The Council insisted that you should have a limited period of time. The Parliament insisted that you shouldn't have any wording that would suggest that you can pick a random number and say, this is it, 3 months, and if you're 3 months and 1 day, then you're not temporarily present. So this is the solution in the end. It was a compromise. It was decided to say for a limited period of time, with Recital 1 saying that the purposes for this temporary present could be purposes such as leisure, travel, business trips, or learning mobility. Again, the words such as mean that this is a non-exhaustive list. These are just examples. And then the last two definitions, online content service and portable. So I'll start with the definition of portable. Portable means that the service, you don't need to be in a specific location to access the service. So you don't have to be at home to access the service. You can access it from wherever in your member state of residence. And an online content service, it's a portable service, which is either an audiovisual media service according to the Audiovisual Media Services Directive, or a service, the main feature of which is the provision of access to and use of online content. So particularly when it comes to this second bit with the main feature, Recital 16 clarifies that not all services are included. If the main feature is not the provision of access to services, but it's just an ancillary one, it will not be included. The Recital gives an example: websites that use works or other protected subject matter, such as graphical elements or music, only as background, where the main purpose of the website is, for example, sale of goods. So if you go on a website to buy clothes and you have some music in the background, that will not be covered by the portability regulation. Next one, Article 3. Article 3 on the obligation to enable cross-border portability, and Article 4 on the legal fiction. These are the two pillars of the proposal. You have Article 3, which introduces an obligation to enable cross-border portability, and you have Article 4, which tells you how this will be enabled. So the obligation to enable cross-border portability of online services, who does it apply to? It applies to providers of online content services against payment of money. However, here it is specified that the payment of a mandatory fee for public broadcasting services is not to be regarded as payment of money. This is in Recital 18. What about the providers without payment of services without payment of money? This was also a discussion. On the one hand, it was considered that it will be a disproportionate burden if you oblige all providers of services without payment of money to provide cross-border portability. On the other hand, it was considered that it would be disproportionate to exclude all those providers from the possibility to benefit from the legal fiction and to provide cross-border portability. So the solution in the end was, in Article 6, that such providers can decide to opt into the scope of the regulation. It is for them to decide whether they wish to take the burden and the benefits of being covered by the regulation. If they decide to opt into the regulation, though, that means they have to comply with all the obligations, including to verify the member state of residence, and they need to inform, before they opt into the regulation, their subscribers and the right holders of that fact. They can inform them, for example, by publishing this information on their website. Who benefits? A subscriber temporarily present in a member state other than the member state. What is covered by the obligation? The obligation is to provide access and use in the same manner as in the member state of residence, including by providing access to the same content, on the same range and number of devices, to the same number of users, and for the same range of functionalities. In addition, the provider cannot impose any additional charges on the subscriber for this cross-border portability. And then quality of delivery. The provider does not have to provide the same quality as in the member state of residence, unless expressly otherwise agreed, but the provider cannot take active steps to reduce the quality of the delivery. And if the provider can provide has information about what would be the quality of the delivery in other member states, they have to provide this to the subscribers. Legal fiction. Yes, this is very similar to what Niels was talking about with the country of origin. It's more or less the same principle. It's a fiction. That means that we know that it is not true. What we're saying, we know it's not true. It's not a presumption. It's not true. And it's legal because it is introduced in the law. So the legal fiction is that the provision of an online content service under this regulation to a subscriber temporarily present in a member state shall be deemed to occur solely in the subscriber's member state of residence. Taking the example of me again. Yesterday I watched a film on Netflix in the hotel here in Germany. My account is in Belgium. Had this regulation become applicable, which it hasn't yet, but if the regulation was applicable, me watching this film, it would have been as if I've accessed it from Belgium rather than Germany. The fiction says, for the purposes of cross-border portability, the subscriber, me, shall be deemed to be accessing the service from their member state of residence, from Belgium, even when they are in a different member state, in this case in Germany. So why do we do this? It's the same logic as with the country of origin, because of the rights, the clearance of rights. Netflix has cleared the rights to give access to certain content in Belgium. That does not mean that Netflix can give access to the same content in Germany, because Netflix might not have the rights cleared in Germany for that particular content. So by introducing this fiction, we are saying Netflix doesn't need to have the rights in Germany, because we are going to consider that Netflix is showing you this content in Belgium, that you're in Belgium and you're watching this content as if you were in Belgium. So it is all ultimately in order not to require Netflix to clear rights all over for every single piece of content. And again, let's not forget, and the recital 23 specifically reminds us that this applies only to cross-border portability. This fiction does not apply to anything else, only to cross-border portability. And then a particular part that I was very happy that made it to recital 23 is that the legal fiction does not prevent a provider from enabling the subscriber to additionally access and use the content lawfully offered by the provider in the member state where the subscriber is temporarily present. To put it again with the same example, Netflix is obliged to give me access to the Belgian content even if I am in Germany. However, the regulation does not prevent Netflix from also giving me access, in addition to the Belgian content, giving me access to the German Netflix content. So Netflix, should it choose to do so, could give me access to the German content as well as to the Belgian. So that is a good one. Verification of the member state of residence, Article 5. That is the longest article of the regulation, and more importantly, there was nothing on verification in the Commission proposal. This was entirely from the Parliament and the Council. Why did the Parliament and the Council feel they need to introduce that? The driving force was the idea to protect right holders. Cross-border portability, it was felt, could be abused. And in order to avoid an abuse where subscribers claim that their member state of residence is here or there, but that is not the case, only so that they can access the content in a different member state, in order to avoid this abuse, the Parliament and the Council decided, okay, we'll need to have some means to verify that when the subscriber says, I am resident in Belgium, we can ask for something that will show that indeed that subscriber is resident in Belgium. So when do you verify the member state of residence? Upon conclusion or upon renewal of the contract, and there is also a possibility provided to re-verify during the course of the contract if the provider has reasonable doubts whether the member state of residence is indeed still the same as initially declared. How do you verify? There is an exhaustive list given in the regulation. You cannot use any other means but the ones in the regulation. Secondly, you cannot use more than 2 of the means in the regulation, which means you can use 1 with some exceptions. Thirdly, the means used must be reasonable, proportionate, and effective. So from that list that you have, there will be some means that will be easier to provide in one member state than in another. And there will be some combinations that will be easier to fulfill than others. So when providers choose the means that they are planning to use, they need to choose in such a way that what they end up with is reasonable, proportionate, and effective. What happens if the member state of residence cannot be verified? Then the provider cannot give cross-border portability on the basis of the regulation. That doesn't mean that the provider cannot give the portability outside of the regulation, but if it is outside of the regulation, then the legal fiction will not apply. And then the waiver of the obligation. This was introduced, again, following the logic that you verify in order to protect the right holders. It was felt that if the right holders say, we do not need protection, then there is no more justification for verifying the member state of residence. And this is why paragraph 4 of Article 5 says that right holders can authorize the provision of access to the content without a verification of the member state of residence. In this case, the contract between the provider and the subscriber will be sufficient to determine the subscriber's member state of residence. However, right holders can always withdraw this authorization, provided that they give reasonable notice, and the right to withdraw the authorization cannot be restricted by contract between the provider and the right holders. Here you need to also keep in mind Recital 29, which clarifies that an individual right holder saying you don't need to verify is not enough to allow the provider not to verify. Netflix provides access to many films. Each film has many right holders in it. Netflix verifies the member state of residence upon conclusion of the contract. At that point, Netflix doesn't know what content I'm going to access. And therefore, for Netflix to be free from the obligation to verify my member state of residence, all the right holders in all the content that Netflix gives access to need to have said, yes, you're free, you don't need to verify the obligation. Because if you have even one right holder who has not waived this obligation, there is no guarantee that I will not watch this one film where you have this one right holder who has not waived the obligation. Protection of personal data, Article 8. Well, when you verify the member state of residence, you process personal data. And if you process personal data, that means that you are interfering with a fundamental right in the Charter, and that means you need to have a justification. And not only you need to have a justification, which as we saw is the protection of another fundamental right, the right of right holders, you need to also have additional safeguards. And this is why we have Article 8, which says that the processing of personal data under the Portability Regulation has to be done in compliance with the Data Protection Directive, which as of the 25th of May 2018 will be the General Data Protection Regulation. and has to be done in compliance with the e-privacy directive, and it has to be limited to what is necessary and proportionate. And then you have a number of provisions relating particularly to Article 5, to the verification of the member state of residence. The data collected can only be used for the purpose of verifying the member state of residence. It cannot be otherwise transmitted or disclosed. It cannot be stored longer than necessary to complete the verification, and it is to be immediately and irreversibly destroyed afterwards. Here you have an addition by Recital 30 that this is without prejudice to the storage of data which was collected for another legitimate purpose. So one of the means to verify a member state of residence is the address. So you can collect the address to verify the member state of residence, but you also collect it so that you can send invoices to this address. So this data is collected for two legitimate purposes. Once you verify the member state of residence, in general, you should delete this data, but because it is still used for another legitimate purpose, so that you send invoices to the subscriber, you don't delete it. You keep it, but you can only use it for this other legitimate purpose, which is still valid. And then IP address checks. That was very much debated, very controversial. If you use an IP address check to re-verify the member state during a duration, during a contract, the data collected must be collected in binary format only. What does that mean? If you're re-verifying whether the member state of residence is still Belgium, the only information that is relevant to you should be, am I accessing the content from Belgium, or am I accessing the content outside of Belgium? But whether I am accessing it from France or Germany or the UK, that is irrelevant. So this is the binary format. You only check whether the access is from the member state of residence or outside, but you don't go into more detail where exactly outside of the member state of residence did you access it. And when it comes to IP checks, there is another rule in Recital 28. When you use an IP check in the beginning to verify the member state of residence from the very beginning, obviously you need to know which member state is the content accessed from. So you need to know, okay, do I access from Belgium? But as we know, IP address checks can provide a lot more information. They can provide which city you're accessing from, and even more. This is information which is irrelevant. So Recital 28 says you have no right to check which city, and even more precise, what exact location is this data accessed from. All you need to know is which member state is the data accessed from, and that is all you are allowed to collect for the purposes of the verification. So as you see, quite a lot of safeguards were added. Contractual provisions, yeah, we have the usual thing. Contractual provisions contrary to this regulation are unenforceable, and the regulation obviously applies irrespective of the law applicable to contracts. What happens next? The regulation becomes applicable on the 1st of April 2018, 9 months after publication. It will apply to new contracts, but it will also apply to old contracts, which are still relevant. So if I conclude a one-year contract today, it will be an old contract, but it will be still relevant because it will continue for several months after the date of application. Obviously, when you have old contracts, that is quite a lot of burden for providers to then recheck the address, well, not recheck, but check for the first time the address of old subscribers. So the regulation gives them an additional 2 months on top of the 9 months between publication and applicability of the regulation. So by 2nd of June 2018, providers of online content services against payment of money must verify the member state of residence of subscribers who concluded contracts before that date. The deadline is again 2 months when it comes to service providers for services without payment of money for contracts that they've concluded prior to the applicability of the regulation. However, there the deadline starts to run from the moment that this provider decides to opt into the application of the regulation. This might be later than the 1st of April 2018. And then finally, by the 2nd of April 2021, 3 years after application of the regulation, the Commission has to submit a report to the Parliament and to the Council. Thank you.